Hey folks, Mark Smith from the Four Boxes Diner here, constitutional attorney, member of the U.S. Supreme Court Bar. We have some breaking news here. I will do bigger videos explaining what all this means. I'll put everything into context. It will be fine. But right now you need to know some critical information that has just occurred at the United States Supreme Court. They've made a series of decisions this morning on their order list. Specifically, they have denied cert. They've denied cert in all the quote-unquote assault weapon bans out of Illinois. This was unfortunate, but not particularly a shocker, because these cases are on what's known as an interlocutory basis. They're on a preliminary injunction stage, meaning they have not reached a final judgment yet. And that is a concern. I've flagged this to you before. For example, just recently, the U.S. Supreme Court issued the decision out of Idaho dealing with the abortion statute, where Justice Alito was saying, why are we taking any cases on an interlocutory basis? Now, the good news is about this, to the extent there is good news, and by the way, I 100% wanted them to grant cert in these quote-unquote assault weapon cases. I 100% think we have to get that resolved at the Supreme Court level. No lower court is going to rule for us as a practical matter, so we need to win the AR-15 and the magazine cases at the Supreme Court, so we need to get those cases there as fast as possible, and the anti-gunners know this. So with that said, though, there was a statement made by Justice Thomas saying that if the Seventh Circuit Court of Appeals screws this case up and finds the most popular rifle in America, the AR-15, is banned under Illinois law, then Thomas basically says we need to take this case and fix it. Justice Alito indicated that he actually would have granted cert in one or more of the Illinois cases, but obviously they did not have the 4 votes to do that just yet. Probably again because of the interlocutory nature of the case, which we've talked about quite a bit before. So anyway, we'll talk more about what all that means down the road, but that's unfortunate but not unexpected that they denied cert in those Illinois assault weapon cases. I thought our best shot was the Bianchi case in the Fourth Circuit, which of course, as you know, was a final judgment, but had just been argued by the Fourth Circuit. No decision is ruled there yet. We'll see what happens there. Now, and as to the 922G cases, as a general matter, the 922G cases I don't love, and we'll talk about why in a second, but the 922G cases, including the Range case, which deals with nonviolent felons, and the Daniels case, which deals with individuals that are using illegal substances like marijuana and cannot possess guns. Both the Daniels case and the Range case and others have been GVR'd, which basically means that they granted cert, they vacated the lower court decisions, and they've sent them back for further consideration and redecision, basically, in light of the Supreme Court's decision in Rahimi. So this was not a super shock. I thought there was an outside chance that he might grant cert in the Range case and deal with the polar opposite factual situation from Rahimi, where Mr. Range has no evidence of violence, but the Supreme Court obviously made a decision to send that back for further consideration in the lower courts. I will say, in light of the Trump decision, if you look very carefully what the Trump opinion talks about, they're specifically saying that they're unhappy that the lower courts did not work harder and take their time and figure out what's going on in the Trump immunity case before it got to the Supreme Court. So I think it's basically a message to the lower courts to do a better job and analyze it before it gets to the Supreme Court. The last case or set of cases you want to consider is the Antonyuk case out of the United States Court of Appeals for the Second Circuit out of New York City. In the Antonyuk case, there are questions about licensing, good moral character, and whatnot. And the bottom line there is that was also GVR sent back to the Second Circuit Court of Appeals to be reconsidered in light of the Rahimi case. As you know, the critical thing about Rahimi, from our point of view, is the fact that they said that not responsible people cannot be disarmed. In other words, the mere fact that you are not responsible as an American does not disarm you as a matter of Second Amendment law. So anyway, so we will break all this down in a lot more detail. Obviously, I'm on the road today, so we're shooting this video just to get this news out to you, but we will break all this down to you. Do not get depressed. I'm not happy about the Illinois cases, but I'm outshot. But again, don't get depressed, because I will lay all this out to you. I think there's a big plan going here, and I'm still optimistic we're all going to be fine, but I will break it down for you when I get home very soon. Okay, folks, make sure you subscribe. Don't forget to follow me on X at 4 Boxes Diner, and we'll see you again soon here at the 4 Boxes Diner.
Orders up. Table 2A.